Good afternoon, students, faculty, and community members. And thank you for joining us here at our latest engagement of the School of Policy Studies Speaker Series. My name is Spencer Jacklin, and I'm an MPA student here at the school. Today, I will be playing the role of host with our speaker, Mr. George Thompson. I would first like to acknowledge the Indigenous territory on which we have the privilege of meeting. The territory on which Kingston is situated has been the site of human occupation for thousands of years, and is the homeland of both the Haudenosaunee and Anishinaabe peoples. We extend our gratitude to the Indigenous peoples of Turtle Island for welcoming us to their territory. I would also like to acknowledge that today is International Women's Day, a day celebrating the social, cultural, economic, and political contributions of women from around the globe. Today, we join women from all corners of the world in their call for action accelerating gender parity and equity, and support their organizing initiatives to build a world in which all women and girls can meet their potential. Now, I would like to turn to introducing our speaker, Mr. George Thompson, an experienced civil servant who has served both Ontario and Canada in several different capacities over the duration of his career. Mr. Thompson is well versed in the worlds of law, policy, and academia. A former judge with the Ontario Provincial Court, Mr. Thompson has also served as the Director of Education with the Law Society of Upper Canada. Mr. Thompson has complemented this experience by working as a Deputy Minister in several different portfolios with the Ontario Public Service, including Citizenship, Labour, and the Ontario Office of the Attorney General. Additionally, Justice Thompson was also appointed to serve as the Deputy Attorney General of Canada from 1994 until 1998. On several occasions, Mr. Thompson has also utilized the experience derived from his extensive career with the public service to advise the Government of Ontario on various matters relating to policy and the law. In 2006, he chaired the Ontario Citizens' Assembly on Electoral Reform. More recently, Mr. Thompson has collaborated with our own distinguished fellow, Senator Hugh Segal, to chair a working group for the province of Ontario that sought to determine how to craft a new income security program based on fairness, adequacy, and accessibility. Currently, Mr. Thompson serves as Senior Director of International Program at Canada's National Judicial Institute. He is also a Distinguished Fellow here at the Queen's University School of Policy Studies. Today, Mr. Thompson will provide us with a lawyer's perspective on the ever-evolving policy process and discuss both new opportunities and challenges for lawyers and civil servants alike when influencing policy. Mr. Thompson's talk is sure to evoke questions among us and promote dialogue between us. We invite all those in attendance to use Slido on your mobile devices to ask questions to our speaker today. Slido will allow you to ask questions via your phone or mobile device in an anonymous manner if so desired. The code for today's talk is MPA 18. Questions will be posted on our Slido page, and if you have not asked a question, or if you have, please feel free to vote on others' questions that you would like to see asked in this talk. Additionally, we will also take a couple of live questions from our audience today. So without further ado, please join me in welcoming Mr. George Thompson.
So thank you very much, Spencer, and thank you very much for inviting me to come to talk to you today. When I was trying to think about what I might talk about, I decided that instead of speaking about one policy area or issue that I've been involved in, I would try to look for a topic that would enable me to use examples from across my public sector career. And as I thought about it, I thought of two things that make my public sector career a somewhat unique one. Not the fact that I changed jobs a lot, because that's sort of a feature of public sector work, but two other things. The first is that I began working in the public service as essentially a deputy minister. I came from a one-judge family court here in Kingston to becoming a deputy minister, and really my whole public sector career was at the deputy minister level. I didn't come with the firm foundation and policy and government that you're going to have at the end of this course. The second thing is I came in as a lawyer, a professor, a judge, and I came in because of that with a firm view that the answer to most problems, particularly the one I took on first relating to children, was just law reform. That was going to solve the problem. And also for a big chunk of my career, I worked in or are part of the part of government that provides legal services to the rest of government, that manages the litigation, that is the government's lawyer. So I thought what I might do is pick three examples of how, over a period of time, because of the perspective I brought to the job, my views and ideas changed and evolved. And just pick 3 examples and then use examples from my career, both ones that I look back on with some fondness as successes and ones that fell somewhat short of that goal, in order to illustrate the points I'm going to make. I do hope to demonstrate the value of learning from both the things that go well and the things that inevitably fall short of that goal, hence the use of the word confessions in the title of my advertised speech. And I also hope I can reinforce what for me was the greatest pleasure of working in the public sector and the public service, and that was the chance to continuously learn and change my understandings, and to do so in company of the best and the brightest people I've ever met, and you have a chance to do exactly that. So I'm going to start first with something that is maybe familiar to all of you and obvious, but something that I had to learn as a newcomer, not about just the joys of law reform, but the limits, the risks, the uncertainties that go with seeing law reform as a way of achieving your policy objectives. Now, one, of course, is the fact that the law reform may not happen, that you have great hopes for, and we all have our list of those. I put 2 of the ones that I think back with some pain about the amount of time I spent on them. The Charlottetown Accord is one that used up a huge part of my life, and gun registration was another big one for me. In fact, I was planning on having that be a symbol of some of the great accomplishments I had as a public servant, and it died a death shortly thereafter, not long after we passed it. So there's that fact, obviously. And then there are the unexpected outcomes that inevitably flow from a legislative process that can resemble sausage making at its best. And a good example for me was that gun registration law. As it was working its way through Parliament near the end, the opposition was raising concerns, why aren't you doing more about bad guys rather than having everybody register their guns? So at the last moment, the government introduced a couple of new gun-related crimes and attached mandatory minimum sentences to those crimes. The gun bill died, or the law passed, but it died 10 years later. But for the next 20 years almost, the test of whether the government was serious about any new crime was whether they'd attached a mandatory minimum sentence to that crime. Unexpected result from what I thought was going to be a very successful piece of legislation. And it's taken the courts, and hopefully this year the government, to do something about the serious problem of mandatory minimum sentences. And then, of course, there's not seeing the factors that can set aside your reform objective, the reform objective that you had in your legislation, that can operate as powerful countervailing incentives in the exact opposite direction. And to use an example from early on in my career, and I use it because 2 months ago I read in the newspaper that the BC child welfare system just discovered exactly the same problem. When I first came to government, I was working in children's services, and we were focused on developing new child welfare laws and policies to help keep children in their homes with support rather than removing them from their homes. That was when we were first discovering problems like the 60 scoop problem that you perhaps have been reading about, and I'll come back to. We introduced those laws and policies. I spoke endlessly about them, and as did everybody else. But what we didn't realize is that there was a little budgeting rule that had been around for a long time in children's aid societies that said you have a fixed budget, but if at the end of the year you discovered you've unexpectedly had to take more children into care, you can send us the bill and we'll cover it. That budgeting rule meant that our objective, we achieved almost none of it for the next 2 years until we realized that until we changed that budgeting rule to create the incentive to support the policy, we were not going to achieve the objective. Simple example, but I think a particularly important one. Third thing I had to learn was the problem of the tendency to see law reform as the objective in itself, rather than to see it as one piece of a cohesive puzzle or selection or a package of change that added together to achieve the objective. And here too I have a couple of examples. In the mid-90s, when I was a justice in Ottawa, we introduced some new sentencing laws. within those sentencing laws was a really important new sentence that enabled judges to deliver what was called a conditional sentence, which allowed people to serve their time at home under conditions rather than in the prison. The law passed really quickly. There wasn't much said about how it was linked to a very important sentencing study of a decade earlier, and very little was done to train and prepare those who were going to apply that law. Within 6 months, judges out there were handing out conditional sentences in cases that were almost impossible to defend. And the reaction to that, because they hadn't been well prepared, was that in no time at all, new restrictions were introduced on the giving of conditional sentences that set aside in large measure the effectiveness of that proposal. But then I have a better example, the Youth Criminal Justice Act. And around the turn of the century, the Youth Criminal Justice Act was introduced, and it was introduced as part of a lengthy process that had a number of key elements in it, including the building of some consensus over time through a number of public and reports, public discussions and reports, legislation with clear guidance but retaining discretion for judges, some investment at the front end and alternatives to custody for kids who were being taken and placed in custody, and extensive education for all the key players in the justice system. In fact, Nick Bala, who's a prof over at the law school, was one of the leaders of that education. Because of that reform has produced basically a fundamental transformation of our youth criminal justice system in this country. Since just before the act was passed, there's been a decrease of about 75% in the number of children in custody in this country. And it's happened with broad support, no complaint, and it's that collection of pieces that added up to a cohesive approach to a policy change that I think made that possible. Then there's fourth, another well-known one, the power of the individual case, the anecdote, the manufactured example to produce law reform that ought to be regretted. Stated very broadly for me, much of criminal law reform over the last 25 years has been the piecemeal addition of individual crimes and rules in response to one-off tragic cases out there that are said to justify that reform. For me, in terms of my career, the biggest example was the child welfare area. Because as I said, we came in with some good evidence-based research that looked at the poor progress of kids in care, children in care, and talked to the enormous importance of, if possible, keeping them in their homes with support, choosing the least restrictive alternative, focusing on a reduction in the number of children in care, and that really happened. Then in the 80s and 90s, individual cases, well publicized, of children suffering tragic abuse in their homes as a result of the always fallible decision-making when you're talking about an area like child welfare, suddenly produced a massive response to individual cases, a review, a whole new law, changed the powers of children's aid societies, and the pendulum shifted and huge numbers of children started coming back into care. And last year, there's a new law that's been passed that's trying to find that balance. But it's a good example of how the anecdote, the individual examples, independently of good evidence-based research and policy making, can produce that result. And then I say with some pain, there's the decision of the Harris government in the mid-90s to use this mythical picture of social assistance recipients as sitting home living in luxury, to then roll back massively the level of social assistance payments and totally wipe out and more the increases that had come as part of a commission study that I'd been part of 6 years earlier. And people living in poverty, they have never recovered from that change, hence the work last year. So one of the reasons I make this first point about law reform is understanding the limits has helped me make a decision to focus much of my last 15 years in my career on not broad change, but how do you improve individual, fallible decision-making amongst those who make key decisions. And I guess in essence, I returned back to the education role that I began with. And I did it with judges. So instead of trying to structure judges' discretion through prescriptive law reform, if we focus on good adult education that focuses on the knowledge, the skills, the understanding of themselves, the understanding of context that needs to lie behind individual decision-making, my view today is that that can be as equal, if not an even more, of a contributor to achieving important goals for the justice system. So for the last 6 months, I've been actually spending a chunk of time developing and delivering a course, an intensive skills-based course for judges on building their cross-cultural competence. Enormously important topic, and I think done well can have more impact than any kind of policy or law reform focused on that issue. As Spencer mentioned, I last year was part of a working group that produced a roadmap for income security reform, and I'm hoping on the 28th of this month something is done about what we recommended. But one of the things we learned there, and we actually learned it from the private sector, is, to pick an example, if your goal is enabling persons with disabilities to achieve greater social inclusion and, if possible, independence, you shouldn't be spending the bulk of your time when they seek financial and other supports getting them to prove how disabled they are. It's counterproductive. If the time you're spending with them is getting them to prove rules that demonstrate, boy, I'm really disabled and unable to achieve inclusion and independence, you're not going to achieve your objective. If instead we spend a lot of time in the roadmap talking about this, instead if you focus on training staff to build the kind of positive relationships and the ability to provide supports that are linked to positive results, instead of that, and get rid of all those rules that are tied to eligibility, your chances of achieving the goal you're talking about are that much greater. So that's number one. Number two. Well, I did that. So, independence and accountability. Once again, a large part of my work when I was involved in the justice part of government was ensuring the independence of key decision makers in that system, which is a fundamentally important principle, whether you're applying it to judges, prosecutors, or the police. And that has been an important element of my career. And to pick an example, when a former prime minister, it became publicly known, was the subject of a police investigation some time ago, it was really important, in fact essential, that I was able to tell the present prime minister that it was a good thing that he knew nothing about it. Wasn't necessarily what he wanted to hear, but it was really important that I was able to reinforce that this was independent of him. Now, obviously, a brief glance south of the border these days can tell you that the issue of possible political interference in investigations and in judicial decision-making is alive and well. But before we get too complacent here in Ontario, if you've read the Ipperwash inquiry, which focused on the decision-making around the death of Dudley George, or if you read a report that was in the Toronto Star about a report in the Toronto Star 2 weeks ago by friend Leslie McLeod that talked about how other ministries were allowed to exert improper influence on the laying and withdrawing of charges within the Ministry of the Attorney General, it suggests that this issue of independence is not an irrelevant one here. However, for me, the big change has been the important and obvious fact, but not recognized till relatively recently, that you can't have independence without some responsibility for how you carry it out. An increasingly important question over the last couple of decades in particular is how key members of the justice system are held accountable, as well as having their independence protected for the decisions they make, and how you ensure independence while promoting the accountability of both the individual decision maker and the system as a whole. So it's not easy. This is not easy, how you find the right balance. And a focus on just one side of the equation, for example, how unhappy one might be about an individual decision made in a particular case. And there have been a couple of examples of that in the last couple of weeks, can be very problematic because it reduces an understanding of the complexity of the two parts of this debate. At the system level, there's been some real progress. Wrongful conviction inquiries have been enormously important in producing systemic change. My wife chaired a commission that released its report last week called the Mother Risk Commission, dealing with flawed hair testing at Sick Kids Hospital and how that flawed expert evidence is used in the child protection system. Another good example, I would argue. Having transparent policies, being transparent about the decisions that have been made. Systemic reviews. For example, 6 or so months ago, the reviews that started to look at the police response to complaints of sexual abuse, sexual violence. A good way of looking systematically at the issue. Reports that demonstrate the impact of systemic racism, like the Truth and Reconciliation Commission. Internal and independent bodies that review decision-making in relation to, for example, the police in particular. And there was a case last year, the Supreme Court a year and a bit ago decided the so-called Jordan case, dealing with delay in the court system, and did a very important thing, which was to articulate the responsibility of the system as a whole to solve this problem, not each player on its own. And that system accountability, it strikes me, is enormously important. So some cases are so linked to the credibility of the system that a review is required, like the wrongful convictions cases. So I was the deputy minister in Ontario when what was later got to be called the deal with the devil was made. The deal with Karla Homolka, the wife of Bernardo, in which she was allowed to plead to a lesser charge than murder, to a manslaughter charge with a 12-year sentence. Something that didn't just seem, that was so wrong when the later video showed explicitly her role in 2 dreadful murders. With the videos, that deal, that decision to allow her to do that was simply not defensible. So it mattered that then a judicial review was done by a highly credible judge to explain why, if you go back and have a time when it seemed very clear that there were no videos and no videos would be found, and there was a clear sense you needed her testimony as a wife who could not be compelled to testify against her husband in order to ensure that Bernardo was convicted, there was some logic in a different approach being taken to her at the time that approach was taken, even though it became a not defensible decision once the videos were there. So it's an example of where review of an individual decision was, in my view, fundamentally important. My link to the independence issue is particularly around judges. And judicial independence is a fundamental constitutional principle. And we've learned a lot about the individual ways that can be compromised. I know you've been reading in California, there's a power to recall a judge if enough people vote to throw the judge out after an unpopular decision. That, for me, is a good example of a direct interference with independence, judicial independence. And it can be indirectly compromised by the way judges are assigned to cases or by the way what they're paid is determined. But the judicial accountability issue more recently has become very much focused on the concept of judicial education, the area that I've been involved in. And it's because of a case, the Camp case, which some of you will I hope, know about or have read about. And that's a judge in Alberta who demonstrated a major lack of knowledge and understanding of context in relation to sexual assault cases. He was the judge who, in the course of a trial, suggested to the complainant that she could have crossed her legs in order to prevent the sexual assault. That judge was appropriately removed from the bench through the judicial misconduct process. But then the government stepped in, and the issue of, well, how are judges being educated to do their work? And how can we be sure they have the knowledge, skills, and context to do their work became front and center. And there's a bill now before Parliament, it's actually at the Senate, that requires judicial candidates. They were worried about, we don't want to interfere with independence, requiring judicial candidates to take a sexual assault course, and some reporting on whether judges who are deciding or hearing sexual assault cases have ever taken a sexual assault course. Nothing much wrong with that bill. For me, the problem of the bill is it's inadequate. It conveys a message that there's some one course you can take, and then you become capable of being a well-qualified judge to decide sexual assault cases. There's also a problem that even though I don't disagree with what's in there, it starts to talk about the content of the courses. And I personally believe that that's a key area. If government starts to dictate the content of education for judges, I do think that the education principle, the independence principle is being challenged. What I think is the answer, and this is something I wouldn't have overall said 10, 20 years ago. First, a credible appointment process. And actually, I only had a modest role in this. The appointment process in this province for provincial court judges is one of the very best in the world. And the judge we're talking about here never could have been appointed, in my view, in the province of Ontario because of that appointment process. But I also think that there's nothing wrong with saying that a part of having your independence is an obligation to do what we expect of all important professionals: commit yourself to lifelong learning. And to say that judges should have learning plans that they annually review and are connected to a credible curriculum strikes me as something you can require of judges and not be frightened of compromising on their independence. You could do it indirectly by saying, okay, you don't have, the education may be voluntary, and that's what it's been up to now. There's no obligation for judges to take the education, and the curriculum is basically invisible. You can say, okay, you don't have to take it, but if we later are assessing your behavior, whether you were committed to judicial education will be a highly relevant factor in deciding whether or not you've misbehaved. And putting resources for a full curriculum that deals with the whole range of things that judges need to learn, and still is judge-led, which I think is very important, but with visibility of the curriculum and visibility of the standards and process for the designing of that curriculum so that we can be satisfied it's being done well. Third, the Attorney General and the rule of law. This is the one maybe most closely linked to the policy process. And this is the task of ensuring that government activity is carried out in accordance with the law. And that's a task that's expressly vested in the Attorney General at the provincial level and at the federal level, or Minister of Justice. An express obligation on that Attorney General to ensure the government is carried out in accordance with law. This slide sets out that common law rule. It's reinforced by statute. It's also reflected in the values that apply to those who do policy work in government, to the public servants. Because the mirror side of that is the obligation, and I'm just quoting the core public sector democratic value, of helping. The role of the public servant is to help ministers under the law and the Constitution to serve the public good. So this AG role, this role of the Attorney General, is carried out in three ways: giving advice to Cabinet when some new law or policy comes forward, giving advice to those who are developing new laws and policies, and then managing all the government litigation, including the prosecution function on the criminal side. Before 1982, that was a fairly easy task. Not impossible, not really easy. There were some tough issues like, does this new law fall within the jurisdiction of the province rather than the feds? Those kinds of issues. But it wasn't as difficult as suddenly in 1982 when everything changed. And in 1982, as you will know, the government introduced the Canadian Charter of Rights and Freedoms. And we overnight shifted essentially from parliamentary supremacy to constitutional supremacy. And we now had a charter full of some very general rights and shared values like what is life, liberty, and security of the person? What does equality mean? And if you're going to limit the rights in the charter, are they reasonable limits as can be justified in a free and democratic society? Very broad, value-laden terms. That's what the charter has, and then it was left to the courts to apply those values to the individual case, with a special statutory obligation in the Attorney General and the Minister of Justice in relation to the charter. That overnight became a major challenge to cabinets and ministries and their perceived right to decide on their preferred policies and directions, because now the charter potentially allowed those to be overruled by the courts. The basic AG role didn't change, but it was also a massive change in how the lawyers had to carry out that function, with potentially a major impact on government policy. And I'm going to give you an example in a minute. So for the next, and I was there when we were going through this learning stage of how to do this. And it was an enormously, and continues to be enormously difficult task. And I'm only just going to take you through some of the kinds of issues that arise when you're now dealing with lawyers trying to give advice to policy people on whether their policies comply with the charter, potentially saying, because of their AG role, that policy can't be implemented because it violates the charter. So some of those issues, and I'll just say them very quickly. First, the obvious task of how do you predict what courts are going to decide? How do you make a prediction on what's going to happen when this goes before the courts? That was, of course, a major problem when the charter was first passed, because we didn't know what the courts were going to do. It's a little clearer now. But charter analysis can be enormously complex. The courts you're worrying about change over time. You know, you put, in the United States, you put Mr. Gorsuch on instead of what the Democrats wanted, and well, it's a different court. So how do you factor that in, to use a US example? A second one, and this became very important, particularly in my role as a deputy, how to factor in and control for the personal and ideological perspectives of the judge doing the analysis. Because we all bring our backgrounds, our experience, our perspectives to the decision-making we make. We all have perspectives on the role of the law. And there were several situations where there was a necessity to say to the lawyers, let's step back, redo the analysis, because what you've given me is your view of the law. We need a broader, more carefully considered perspective on how that law, how the charter would apply to this. It's a potentially big problem for the Attorney General, who's a member of cabinet and therefore has a political role, but also has this AG role of potentially telling them, I know this is what we want to do politically, but you can't do it because of the charter. Then there was the huge issue that still runs, is how do you define the risk for the people who are developing a new policy? And I hate to tell you the number of hours of my life spent talking about this range of adjectives that would change over time and trying to figure out what's the difference between something that's minimally risky or significantly risky. How about substantially risky? Or maybe we should say this one is seriously risky. When does a new policy become unacceptably risky? Or a phrase that gets talked about at the federal level, manifestly inconsistent. Hugely difficult challenge, and sometimes those discussions started to be very surreal in my role. But then, of course, there's the question of what does it mean? So once you've given that advice, what do those adjectives mean? Do any of them mean you can't, ministry or whoever's developing the policy, you can't do this? Or is it all just advice to be considered along with the economic impact and other things and to be followed or ignored? When on that little line, if you get down to this right end of the spectrum in terms of adjectives, when are you saying my Attorney General role tells you you can't do this? You can't do it because it's clearly inconsistent with the charter. And what happens if you have a government that says, we don't care what the courts will do? And in fact, it's kind of politically worthwhile to take whatever position we want and then complain when the courts disagree. What is the role of stepping in and saying there's a line you can't cross in that context? Or can it say, we're only going to accept the advice when you tell us it's manifestly inconsistent, and the rest of it, thanks, we'll look at it. Then there's the situation where somebody has started a case arguing that the charter's been violated. And now the lawyers of government are managing that litigation. And then you get into questions of who decides what position to take in court. Must the lawyer always take the position preferred by the ministry whose policy is being debated in court? When should the Attorney General say, I'm conceding the breach? In fact, one of the earliest cases of an Attorney General publicly saying, I'm not going to defend this, it actually related more to the Human Rights Act, was Ian Scott saying, I'm not going to defend a human rights complaint saying the girls can't play, arguing that it's wrong to say the girls can't play hockey in the city of Toronto. The key thing is he said, I'm not going to defend that. I know that that violates the legislation, and that's my role as an Attorney General. Well, how does that work when litigation is going through? And then I'll come back to number 6 there. But I just want to take you through one quick example that demonstrates that I was part of, that's a good example of how this area can be messy and complex. And that's the area of same-sex rights and benefits. Okay? And an area where charter litigation delivered and the decisions of attorney generals delivered a major policy shift at the provincial and policy level. So let me just take you through those steps. It began with a case called M&H. M and H were in a long-term same-sex relationship, and when it ended, M sued H for support, saying, it's unconstitutional not to allow me to sue under the Family Law Act for support. I should be treated as a spouse for the purposes of that act. That was the case. My minister, Marion Boyd, and we have spent a lot of time looking at where in that line were we. She ultimately said, I'm going to Cabinet to tell Cabinet, I'm going to concede the charter breach. We are so sure in our prediction that this is contrary to the charter that we're going to concede this, and told Cabinet that. It was an interesting meeting of Cabinet, but that happened, and we filed a concession saying we're conceding that she's right. The Act breaches the charter, the equality principle under the charter. So then she came back shortly thereafter to our help and saying, well, if I'm going to concede the breach, I've got to do something about it. So I have legislation, and we've got to pass legislation now. We're required to do that because of what I am telling you is the law. We have to pass legislation to create a new definition of spouse under the charter to include same-sex partners. And when people said, well, could we maybe carve out adoption, or maybe we could have another title than spouse, maybe we could create something called a civil union or something, she said, no, you can't do that. I'm sorry. The law, as I interpret it, in my role as AG, you must pass this, you must put this legislation forward, which was done with the support of one of the opposition parties, but then when it got to the legislature, the bill was defeated when the opposition party withdrew. One of my saddest days in public service, made worse by oh, I'm sorry, I've got a little picture here. By watching the OPP lining the legislature steps as the advocates for this legislation came out of the legislature, all wearing white gloves as though there's something that they could catch from these people walking out of the legislature. Very depressing. So then I left and went off to the federal government, and a new government came in, and they with the same advice, withdrew the concession. Said, no, we're going to fight this case. And they fought it all the way up to the Supreme Court of Canada. I, meanwhile, had gone to the federal government, and now we were dealing with federal benefits. Cases being brought saying, well, a same-sex spouse should be able to get bereavement leave, or should have their expenses covered when their partner is posted internationally. And we were asked by the government to keep fighting those cases, and we lost them steadily, one after the other, but primarily because the government couldn't take a policy position. And then finally, the Supreme Court said that M&H, our concession, was right, and in fact it was unconstitutional. At which point the government then introduced a bill that had a bit more formal title. Basically, when you looked at it, it was called the Courts Made Us Do It Act. And that changed things provincially. And then 2 or 3 years later, the courts, the Supreme Court dealt with the federal area by saying marriage should be permitted between same-sex partners as well. So, why this part is important, I'll just say this very quickly and then I'll stop. is because I think it really does require us, you in your role as policymakers, to step back and recognize that the world has changed. And you can't think of the Charter and its impact as something to just consider in the course of making your legislation. It actually has a much larger and more fundamental role than that. It means early involvement of lawyers in the policy process, not just to tell you whether it's constitutional, but to help you learn how to achieve your policy goal within the Charter, because that's the real issue. How do we respect Charter values and still achieve the objective? I was here on Tuesday when Nathan Obed was here from the Inuit communities, and he was making the very same fundamental point about those indigenous rights that were also introduced in 1982. Don't treat them as rights that are only relevant when somebody sues you. They are fundamental rights that should guide your whole relationship with indigenous communities. That's true, in my view, for the whole issue of the Charter. Early identification of cases raising Charter concerns. I'm a strong believer in joint training of policy experts and legal experts on how to do this, and I think it would be an enormously valuable course here between policy students and law students. And greater transparency of government analysis under the Charter, and Janet Hebert is here who knows a lot more about that than I do. And the last thing I just want to mention is the class action. You've heard of class actions where the whole class gets together with a common claim and sues for relief as a class. Way more of those now than before. It's a very major part of activity before the courts. The way those things work, and those class actions have significant policy impact. I've just put 3 examples there. The Huronia case dealing with deinstitutionalization of developmentally disabled persons, challenged persons. The recent class action relating to segregation in prisons. The 60s Scoop case dealing with the removal of Aboriginal Indigenous children in the 50s and 60s through the child protection process. The way those things work is that you apply, and then there's a moment when the court decides whether or not to certify your class, to say it's a valid class. And that has traditionally been the big moment. Nothing happens after that, because once the class is certified, then it's all just settlement. How are we going to settle this case? They never go to trial, or almost never go to trial. So that certification process becomes the big thing. And my experience has been, and I'm hoping it's changing, that people wait until certification to actually try to deal with this. And when they wait too long and don't think about the policy implications right when the class action has begun, the whole settlement becomes one of money and the size of money payments, which I'm not against. But I think it's not enough. And the year I was here as a Skelton Clark Fellow, a lot of years ago, I spent a year working on this residential schools file when it was early in the class action, trying to work across the country with survivors and the churches and the lawyers and the government to develop community-based solutions, community by community, that would involve the community as a whole settling this case, and not just dealing with compensation, but also dealing with healing and how that community can heal as a result of it. But I was too late in the process. Even though we started some pilots that really were starting to work, the government lost interest and got worried about the class, and then everything turned to settlement of the class action. And it's embarrassing to even suggest any criticism of a settlement that produced the Truth and Reconciliation Commission, because it was so fundamentally important. But I think if that exercise had begun at the beginning rather than halfway through, there could have been a chance to complement that settlement with answers that could have been more policy-driven. So that's it. I'm sorry I ran on a bit long, but those are my ways of illustrating the importance, I think, of law and policy making, and I hope also reinforcing the enormous value that you will have as you go forward in learning about the things that do well, but also see all of those challenges happen, the things that don't go so well, as the enormously valuable learning experiences they were for me. Thanks very much.